hard to think of one moment or something where I think that I would be particularly proud of, but I think there are some highlights in the work that we did as a team, and I think the Krstich case was the first genocide conviction in our tribunal and the first recognition of genocide in Europe since the Second World War, or since the Genocide Convention and after Eichmann. So it was a pretty important moment in the jurisprudence of the tribunal that we were able to ensure that the law developed in a way that the law related to genocide, the law related to crimes against humanity, and the law related to war crimes was maintained. The other thing is maybe this is a bit technical, but there's a big debate, or was a debate, and probably still is a debate as to whether or not someone can aid and abet a genocide, whether or not someone can assist someone else's genocide. And we worked pretty hard and fought pretty hard to have that recognized on the basis of the fact that someone who assists another in the commission of a crime, including the commission of genocide, if they do so with knowledge, of the other person's crime, that should be recognized as criminal, even though they themselves may not have the genocidal intent or the intent for persecutions. And this concept of aiding and abetting, with the idea that people who assist others, knowing that by assisting, they're assisting in the commission of these important crimes, that should be recognized as criminal as well. And that was one of the areas that was developed over a long period of time and culminated in the genocide appeal in the Krstich case, and was recognized as a way in which you can capture criminal conduct and hold people accountable. So those were that was one of the cases that I enjoyed the most, found it to be most difficult intellectually and challenging, and felt that at the end of the day it was a proper and good result. So yeah, the capture of Krstich, I was present the day that we found out, and was in the room when the news came through the information channels that we had. That was a pretty special moment. We were looking at closing down. We'd been told that had to start reducing. We were told that the tribunal budget would be reduced in 2009. That this year, the year that we're presently in, we would have already been reduced by 1/3 by the end of this year. And we were concerned that the tribunal would end before one of the persons who we think should be tried would not be brought to justice. And so that was also a pretty special moment. Though I take no credit, I had nothing to do with it. It was just really, really, really wonderful to be there at the time that it happened, and to think that we had a chance to, at least, whatever the result, bring him to justice. Jackson represents, well, for us, partly because of his opening, which is so well known, he represents a very important component of the development of international humanitarian law.
The Nuremberg Trial as being really the first international military tribunal, which laid out the concept of holding individuals accountable. Do you get a sense of the legacy of that? Is there a continuum in what you're doing?
Yeah, absolutely. I mean, clearly, there's even things that we haven't even got to yet that I think have already been, at least initially, addressed in some of the cases that happened at Nuremberg. If you look at the industrialist case, the Farben case, I mean, I was at a conference in Berlin about a month ago, and the topic was criminal responsibility for corporations. And the case that led off the conference, and one of the areas of discussion, was how the law has developed since the Farben trial. So even today, when we're talking about the prospect of a change in the law or a development of the law to hold corporations accountable during times of armed conflict, and corporations that are involved in supporting regimes that are committing war crimes, an area that hasn't been developed, and an area that isn't an area that we have jurisdiction, and the ICC has no jurisdiction over corporations. We have only jurisdiction over natural persons. But though this is an area that people are starting to look into, it's an area that's developing, and there's a number of people that are interested in it. The starting point was back in Nuremberg, where we read the case and looked back on the Farben and some of the others, and looked at the case of the industrialists to look and see how they tried to hold them accountable, and why they went after them in supporting the regime, and how they could look at their conduct as criminal, even though it was by many people considered only economical. Right. So yes, it's still to this day. I mean, even on areas that haven't developed yet, we're still looking back as the starting point. And it's fascinating because we don't read them for that purpose. We read them for the purpose of looking at what happened at the time. We don't often see them in light of where they were going or whether they were precedent setting, because we need to look at them for what were the elements of the crime, or could they hold someone accountable under international law in 1945 in this area. But when we started doing it, as many others I'm sure have said, when we started developing the law and we started looking at things such as the way in which you can hold superiors accountable, or the way in which you can hold persons accountable who are not military commanders, we started out looking, back when I was the head of the appeals section for the Rwanda Tribunal and the Yugoslav Tribunal, the first place we started was the Nuremberg, and we ended up hiring people who were experts in the area, because many of us know of them but aren't specialists, and we needed to take what we could and derive from them. So no, they're still, to this day, there's a thread of Nuremberg that's found in the drafting of our motions, in the filing of our briefs, and in the conferences that we attended. It's really quite striking. And then you see the link back to, you know, the people like Mr. Kaming or Mr. King or Mr. Harris, the people that have been here in the past. And then it even seems smaller, because when you realize that you have some link back to these people who obviously are the forefathers of what we were doing, and the group remains quite the same, it's really amazing to think that there's a core group of people that are doing it, and many who have come before us. The really beneficial aspect of it, that is, that I don't think, or at least I hope, that it won't remain a small group of people. It will be the people that were at the conference. It will be the students that attend. If it can be expanded to that extent, it'll be much more powerful and have much more an influence in domestic jurisdictions. Yeah. And then we won't be coming and being the only ones at the conferences anymore. You and I, we will see many other people and many, many new faces. And then we'll be talking back in the day as if it was, some time ago. So anyway.
Well, thank you very much for coming. This is great.
Well, thank you very much. Thank you for the invitation to attend, and thank you for taking the time out, and thank you individually, the Jackson Center, for the opportunity to be here and to speak. Appreciate it.